আমি কোন ছয়টাই বলবো, 26 26
ভিতরে আমরা ছুটি দিচ্ছি।
Almost without certified copy. Lordships, leave to mention one mandamus appeal without certified copy, Your Lordship.
My lord, same here. My lord, I want to mention by matter, it's a restoration application against the breach of peace during festival. As it's very urgent, lordship, as
You give the letter.
I have already served the petition, served the copies to the opposite party, lordship.
Yes. Please call the list.
ওটাও দিয়েছি, ওটা আমি দিয়েছি।
Appellate side daily list on serial number 1.
Circuit bench.
Some correction you said.
Yes, your lordship.
You give that corrected.
Lordship, paragraph 8, that is of page 3 of the order, Your Lordship.
Please give. Now the 50,000 from the bank guarantee and
Lord-
pen,
Lordship, actually, there was an inadvertent error in submitting that the penalty amount amounting to rupees 4,95,945 should be adjusted. There was no bank guarantee, Your Lordship.
no bank guarantee.
No bank guarantee.
I think somebody mentioned the other day.
My lord, that was a error on my part, in fact.
So actually that 495,945 has
Was
been
paid
Lordship,
by way of a
the
challan.
challan-
That has to, remaining has to be refunded
Yes, Your
Yes.
Lordship.
or recredited.
Refunded, my lord.
Refunded.
This was the challan, my lord.
Matter has been listed under the caption to be mentioned. It is pointed out by the learned advocate for the appellant that an inadvertent error occurred while making submission, which led to a direction being issued in paragraph 8 of the order, stating as if a bank guarantee has been furnished by the appellants, whereas no such bank guarantee has been furnished, but the appellant has paid a penalty amount of rupees 4,95,945. Therefore, paragraph 8 of the order dated 16/6/2023 shall be substituted with the following paragraph. New paragraph 8. For the above reasons, the appeal as well as the writ petition are allowed, and the order of penalty passed by the adjudicating authority as affirmed by the appellate authority are set aside and modified with the direction to the appellants to pay a penalty of rupees 50,000, which will include both CGST and WBGST instead of 200% penalty as imposed by the authorities. The appellant is entitled to adjust the sum of rupees 50,000 from the amount already paid, that is 4,95,945, and after such adjustment, the remaining penalty amount collected from the appellant shall be refunded to the appellant within a period of 3 weeks from the date of receipt of the server copy of this order. This order shall form part of the order dated 16/6/2023. You mark the appearance, no? Vinesh Sarapal, TMCB.
Grateful, Your Lordship.
Grateful.
Yes.
Serial number 2.
Lordship, I am for the petitioner.
Serial 2,
Lordship, I have served upon the respondent. Lordship. Lordship, I have filed this public interest litigation because Lordship, democracy is the basic stand of our constitution, Lordship. And election is
no, no,
also
see, one
vital,
thing,
Lordship. In this
some violence is there occurred, etc.
violence have
But
occurred.
please hear and then respond. The individual candidates have gone before the learned single bench. Some orders have been passed etc. direction to accept. Now the last date for filing nomination is over. At this juncture, let the aggrieved person come before the court. This can't be at the instance of two people as a public interest.
Lordship,
Because already we have entertained, issued directions, etc. Some contempt was filed. Today at 12 o'clock, contempt is being heard. Some single benches have issued directions, appeals have been filed. This vague prayer commanding them to take necessary steps to receive the nomination, how to do it after the last date. Let the individual candidates come, or you lodge a complaint, specific complaint. 1, 2, 3, 5, 6, 700, 100, 200 candidates have not been able to do. Then they will consider. If they don't consider, then those candidates can always come.
Lordship, here the also violated the statutory duty. Intentionally violated the statutory.
No, this is a very vague prayer, sir. I'm sorry.
Not only
What we can do is, you please withdraw this with liberty to the aggrieved person to approach the SEC, and if no redressal, you can work out your.
Lordship, kindly appreciate, Lordship. Also, public is aggrieved because Lordship, the
See,
democracy
we
right
can't-
has been.
We have already in our decision held that those writ petitions were filed not with the purpose of interdicting the election. So, you know the several judgments of Supreme Court, to what extent interfere. Already the election schedule has been announced and some direction was issued, etc. Now you say some candidates could not file. Who are those candidates who could not file? This is a very vague prayer. Yes, you can approach the election commission.
At least
Yeah.
state election commission should
The petitioner seeks for a very wide relief for taking necessary steps to receive the nomination papers of the aggrieved person
mock cutting system in all the 27 seats in a block. And I have losing my right to cast votes. They will go uncontested. Is it believable that in a block where there are 270 seats, all 274, I'm giving chart, your lordships. Can you have a look at my paragraph?
But 274, there are no.
Except ruling party candidates, none.
Very
How is it possible, my lord, in a multi-party democratic system that no one will come up to file their nominations? And how can I choose, your lordships? I am losing my right, constitutional right to choose a candidate, my representative. I'm losing my right to cast vote. That's my point before your lordships.
This seems to be very abnormal. 274,
Your lordship, I'm giving the details, your lordships.
there are 10 gram panchayats, 30 samitis, and 3 zilla parishad.
None. All are uncontested, my lord. All. I'm not a contested candidate. I'm not contesting. I'm frankly speaking with your lordships. But I have a right to choose.
We are examining a larger issue as to whether is it possible and feasible that 274 seats can remain uncontested. And there is not even a single candidate, single person, not candidate, single person who is desirous of filing his nomination in any one of the, for any one of the seats in the 10 Gram Panchayats, 30 Panchayat Samitis, and 3 Zilla Parishad. Therefore, we direct the first respondent, the West Bengal State Election Commission, to file a report on the issues highlighted in the writ petition. And the court will decide as to what further orders are required to be passed in this writ petition. Let the matter be listed on Monday, higher on board. Report be filed
My lord,
on the
my lord,
second,
election commission is the third respondent, my lord.
third respondent.
Yes, and my lord, I am not the additional government leader, my lord.
Oh,
I am the
additional-
senior standing council, my lord.
You will become additional government.
No, my lord, subject to my lord, what my,
AG is there, he
No,
will
my lord.
become special government leader.
my lord, no, my lord, I am in a, I am retainer of this, I am not.
My lord, that the investigation is not being properly done, in spite of the state having filed an affidavit and brought everything on record, including, my lord, extracts from the case diary, my lord, on the basis of, my lord, oral submissions, without, my lord, there being an affidavit in rejoinder, dealing with the affidavit, my lord, of the state, my lord, and the notes of submissions filed by the state, my lord, now it
No,
start.
if the charges have already been taken on file
Yes.
by the concerned court, they can move the concerned court.
Absolutely, my lord, that's my
Further
point, my lord, that's my point, my lord, now start reinvestigation.
No, one of your officers has been asked to.
Monday, Tuesday, Wednesday, any day, your lordship, please.
But then is the contempt pending?
Yes, they
Just
filed.
filed, but
Then
nothing proceeded.
See, you are asking for an adjournment and simultaneously proceeding for the contempt will not.
Just file, your lordship. Now, till date, there
So
is
you
no
say you
progress.
won't move it.
As your lord, if your lordship keep this on Wednesday, Thursday, any day, we will not take this matter before the honorable court. The contempt is pending. Anytime, your lordship, please to take
We
this
have
matter
heard
fixed.
the learned advocate general for the appellant. The learned advocate appearing for the respondent writ petitioner seeks adjournment on the ground that his senior is not available today. The learned advocate general submitted that the appellants are under threat of contempt. Since adjournment is sought for by the respondent writ petitioner, on behalf of the respondent writ petitioner, the contempt petition which is stated to have been filed shall remain stayed until further orders. Let the matter appear in the same position next Friday.
Obliged, sir.
Deeply obliged, your lordship.
Thursday, next Thursday.
Next, sir. The ballot box.
Deeply obliged.
Yes.
Lords, may I candidly submit, my lord, service is not yet complete, my lord.
My lord, we have not received the copy of the appeal, my lord.
What order was passed on 5th April?
My lord, kindly see, this is my.
That was withdrawn and
Yes, my lord, and allegation is made against the advocate that he made the wrong submission and mislead the court, my lord, kindly see.
Mr. Anil Duga
Yes, my lord. My
made
lord,
incorrect and wrong.
I stated that we have not received on instruction. And my learned friend said that we have served the copy. And the learned court said that instead of going into this issue, I allow you to file the appeal on and the date of receipt of the order will be considered on the date on which order was passed. Now, on the next day, my lord, the advocate appearing on behalf of the department said that we have received the instruction from the department that it was served, which was the earlier submission, my lord. And thereafter, my lord, the court took the view that I have misled the court, my lord.
Now you challenge the order in original.
Now, my lord, yes.
You challenge the order in original dated.
No, my lord, I said
in
that
the requisition.
I have not received the order in original. They said that it has been served. We said that if it has been served, onus lies upon them to show the record that it has been served upon the assessee or his authorized representative, because it is the no longer resting together.
What was the mode of service?
My lord,
Mode of
through
service
post
through street post.
and item we received is confirmed. And there is a mode of service specified in the state.
On what date it was?
My lord, it is served on, my lord, 13/5/2022.
13/5/22.
22.
And he has got 90 days to file an appeal.
Yes.
My lord.
And on what date it expired?
But
You give the
13/5.
6, 7, 8, 9, my lord.
18/5, my lord.
Huh?
18/5/22.
13/5.
35
sorry.
is the date of receipt. So
13/8 August. 90 days if I take, my lord.
yes, 12th August.
12th August 22, you
22.
should have filed it.
And my lord, I received the information from my banker. Thereafter, I keep on writing to them to provide the copies of the order, my lord. They did not provide. Thereafter, I approached the writ court, my lord. I have written at least 6 to 7 letters.
But is that the correct address to which it was?
My lord, I am praying apology, my lord. I have the one copy, my lord, since I have not received the copy,
you
my
just
lord.
tell. That's
It is appeared, my lord, from the, my lord, if your lordship kindly see, this is the address. I am just placing your
You
lordship.
read the.
My lord, the address is Messrs. TL Air Engineering Company, proprietor Mohammad Tohid Mondol, 1396 Lima Place, Purvo, Sri Krishnapur, Purvo Medinipur, 721835. This is the address mentioned.
But the address in the writ petition is something different.
My lord, what is
Say,
address?
3rd floor, 3/8, Akash Ganga Complex, Manjushri, Haldia, Purva Medinipur.
Lord,
Yes.
copy, my lord.
And to which address the order in original was, I mean, his show cause notice was served.
So cause notice was handed over by, my lord, the authority himself to the petitioner himself, my lord. It has been, my lord, annexed at page your lordship will find,
And one thing,
my lord, page number 81.
একটু দেখি আমার কাছে এক্সট্রা কপি আছে আমি একটু কপিটা ফেলে দাও। And if your lordship kindly come to page number 38, that is the address mentioned, what address we have served. He has refused to accept, my lord. Page 78. Thereafter, my lord. Page 79. This is the envelope cover, my lord. If your lordship kindly see 3/9/2019, you have served, my lord. If your lordship kindly see the remarks here is refused.
A change of address.
No, there
They
is
have
no
not
change of
included
address,
anything,
my
my
lord.
lord. If
But
there is change about it, this should have been.
complete address is, my lord, TL Engineering Complete, Engineering Company, 3rd floor, 3/8, Akash Ganga Complex.
No, no, you come to page 77.
Yes.
It says 1376 Lima Palace, Purva so and so, Purva Medinipur. This is something else, some other address, and your address now says Akash Ganga Complex. Your letter pad says Akash Ganga.
Yes.
Then why did you send it to this Lima Palace?
My lord, I have
These
to
are the
check, my
letter
lord, whether in
of-
the show code notice.
These are the letters of 2019, my lord.
And the 78, my lord, he has refused to accept your lordship. Thereaafter,
There is
my
no
lord, can
endorsement that we have.
kindly see
refused.
thereafter, my lord, there is an endorsement of refuse. Show code notice.
Acha, acha.
Let him file an appeal
My lord, and they have, my lord,
My lord,
recovered 18 lakhs, my lord,
already.
my lord. I'm just,
And that can be adjusted
yes, with
towards
7
free
pre-deposit,
deposit.
pre-deposit.
On what date 18 lakhs was recovered?
My lord, I have annexed the statement, bank statement, my lord.
Date.
Date I'm telling you, lordship. It was recovered, my lord, on 27th January 2023. Page 34, my lord. Page 34.
And you have now got a copy of the order.
No, my lord, still I do not have.
May I submit one thing? May I come back, my lord, because I have to go through. If your lordship kindly
No,
give me
no
one
coming
time.
back and all. What is that?
My lord, the thing is that I have not received what he is saying. I just give me one thing, my lord.
You have made your submission. Come.
No, my lord.
This intra-court appeal by the writ petitioner is directed against the order dated 13/4/2023 in WPS 6503 of 2023, by which the writ petition was dismissed. The petitioner filed the writ petition alleging that the order in original passed by the respondent authority
Dated,
demanding-
my lord, 29th April 2022.
dated
29th April 2022.
29th April 2022, by which, what was it, service tax,
Yes, service tax.
by which a sum of rupees 18 point,
No, my lord, 18 is first demand. Thereafter, they have raised another
by
demand
which,
against.
by which there was a demand for service tax.
Yes.
The, full stop. It appears that initially the learned writ court was of the opinion that liberty may be granted to the appellant to file a statutory appeal. However, subsequently, upon hearing the submissions of the learned standing counsel for the respondent, the court came to the conclusion that correct facts were not placed before the court, and therefore the writ petition stood dismissed.
My lord, may I want to interrupt one thing, my lord. If your lordship kindly come at page 88 once, my lord.
88.
Page 88. And this is their letterhead, my lord. On 8 December 2022, they are reading, my lord. If your lordship kindly see the details of the address given, my lord. If your lordship kindly see
Correct.
request
It
to
says Lima Palace.
yes, my lord, Lima Palace. What is the address we have issued the so my order in original, my lord?
You please see page 88.
Page 88, my lord. I am looking, my lord. Page 88, my
88.
88, my lord, 88.
The letter pad says Akash Ganga.
But your lordship, the thing is that thereafter, my lord, your
And
reference.
you see this letter, kindly refer so and so, sent by post to my concern, received on so and so, asking to pay. Bring to no demand notice for service tax with penalty has been served to my concern, and thereafter no correspondent has been received. Registered service tax also provide a copy of the demand notice and other correspondence. And in this,
And in the
name of the proprietor, his address is Lima Palace.
Lima Palace, 1396 Lima Palace, Purva.
But the name of the company is the 3rd floor Akash Ganga Complex.
We have issued the my lord, order in order to the proprietor, address of the proprietor, my lord. Where is residing, my lord? This is the address. There is no denied that he is not residing there, my lord.
Now page 90 you have forwarded.
Page 90, my lord. We have forwarded. This is not there.
No, this is a recovery notice.
Recovery notice, but they have received the recovery notice. And it's the same place, my lord. We have
Lord, this is
served the order in
recovery
original.
received from the department, my lord, from the bank.
All right. Was dismissed. Stood dismissed. The learned senior standing counsel will vehemently contend that the order in original was served in the office of, in the address of the proprietor at 1376 Lima Palace, Purba Sri Krishnapur, Purva Medinipur. The address given in the letter pad of the appellant is 3rd floor, 38 Akash Ganga Complex, Manjushri, Haldia, Purva Medinipur. The learned standing counsel for the respondent would submit that the appellant had refused to receive the order which was sent by speed post.
Normal.
Under normal circumstances, the court will not grant any indulgence for a person who has not been diligent. However, in the instant case, it appears that the show cause notice was personally served on the proprietor of the appellant on 7/11/2019, and thereafter he has participated in the proceedings. And as of now, an order in original has been passed on 29/4/2022. Further, we note that on 27/1/2023, a sum of about 18 lakhs has already been recovered by way of bank attachment. Thus, considering the peculiar facts and circumstances of the case, we are of the view that the appellant can be granted liberty to file a statutory appeal. This direction is issued. This direction is issued considering the peculiar facts and circumstances of the case and shall not be treated as a precedent. In order to enable the appellant to file a statutory appeal, the respondent authority is directed to in order to enable the appellant to file a statutory appeal, the proprietor of the appellant is directed to personally go over to the office of the Assistant Commissioner,
Lordship.
Central GST and Central Excise Haldia Commissionerate on a working day within 3 days from the date of receipt of the server copy of this order. On the said date, when the proprietor appears in person before the Assistant Commissioner, a true copy of the order in original shall be handed over to the appellant or to the proprietor of the appellant, and with the said true copy, the appellant is entitled to file a statutory appeal, which shall be received by the appellate authority, and the matter be considered on and the appeal be considered on merits without rejecting the same on the ground of limitation. So far as the question of so far as payment of pre-deposit for filing the appeal is concerned, the said amount of pre-deposit payable shall be adjusted from the amount already recovered from the appellant. The appellant shall file the appeal within 1 week from the date on which the true copy of the order in original is handed over by the Assistant Commissioner to the proprietor of the appellant.
May I submit one thing, my lord?
This order shall not be treated as a precedent.
My lord, after filing
may
the
I
appeal, my
submit
lord,
one thing,
all
my
the recovery proceedings shall be, my lord, stand withdrawn. my
This is
lord.
the rules. So upon payment of statutory
Lord,
pre-deposit, my lord, this is the rule.
let-
Not required, my lord. Not
Let
required
it
to record, my
maybe
lord.
recorded, my lord.
Why? My lord, one thing may I submit, my lord.
Disposed of.
My lord, one thing, my lord.
Yes.
My one indulgence, my lord. Since the department has already recovered, and my lord, it appears that there is a lacuna on the part of the petitioner. If your lordship kindly, instead of directing the department to adjust that amount, direct to keep it in a separate account, let them pay some. If your lordship can.
Next.
My lord, one
Serial
suggestion,
number
my lord,
7.
This order, this portion of the order may be explained. My lord, kindly see it has got the personal remark of against me, my lord. Page number 68.
In
my
the
lord.
light of the above direction, the remarks which have been made in the order impugned, in the order passed in the writ petition, stand expunged in its entirety.
I'm good.
My lord, I am led by Mr. Shivshankar Banerjee, my
Yes,
lord.
Shivshankar.
Serial number 7.
না না বেশি করছো এই ঘরে চলে না কি Well, may I submit?
Yes, sir.
Well, this is a very small issue in this matter, my lord. And may I submit that this issue, the proposition of law, my lord, which I am going to make, that this has already been decided by the Honorable Supreme Court, and an analogous issue has been decided by your lordship also. So, my lord, what is the issue in this petition, my lord? The issue is that for the period of November 19 to March 19,
November.
November 19 to March 19, my lord,
Hmm.
I filed my return from 18th
March 20, November 19 to.
March 19 for 5 months.
Hmm.
5 months. I filed my return beyond the due date of the filing of the return, which is 20th of the next month. I filed all these 5 returns from between 18th of November 2019 to 21st of November 2019. Between these days, I filed my return. Now, my lord, the case of the department is because I have filed my return beyond the date prescribed in section 16(4). So I am barred from claiming this input tax credit. So that is the interpretation given by the department, my lord. My lord, kindly have a look at the order in appeal, my lord, at page 73. It's a very short order, my lord. I am reading out from the records portion, page 73, my lord.
Yes.
From the records, my lord, from the top, the paragraph where it starts with from the records, it is observed that the reason of imposing tax penalty and interest are as follows. From the database, it was detected by the adjudicating officer that the RTP has submitted returns in GSTR 3B for the November to March 19 on the following dates. But there is no dispute about it. There was a delay in filing of the return. Total ITC claimed by the RTP under the different tax for the those period is 28,64,780. The adjudicating officer stated that there is a wrong availment and utilization of ITC amounting to rupees 28,64,780 as which is to be recoverable from RTP under section 74 of the GST Act read with section 620 and so with so and so section. In his opinion, as per provision of section 16(4) of the GST Act 2017 and section 20 of the IGX read with section 16(4) of the CGX, no input tax can be claimed in respect of any invoice for the supply of goods or services or both after the due date of furnishing of return under section 39 for the month of September following the end of the financial year to which such invoice or invoices relate or so and so. Then subsection 4, it quotes a registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or services or both after due date of furnishing of return under section 39 for the month of September following the end of the financial year to which such invoice or debit note pertains or so and so. He also opined that the statute has the time frame as stipulated in subsection 4 of section 16 of the GST Act within which a taxable registered person can claim ITC. The enactment provides that no registered person is eligible to take input tax credit in respect of any invoice or debit note for supply of goods or service or both after due date of furnishing of return under section 39 for the month of so and so. But there is no quarrel with the opinion given by the officer. The only, my lord, the issue of interpretation is, my lord, kindly have a look at section 16(4) once more. A registered person shall not be entitled to take input tax credit in respect of invoices. So, my lord, the word used is taking of the credit. Now, my lord, kindly refer to section 41, my lord. Section 41, my lord.
Is it extracted somewhere?
But what my submission is, my lord, that there is a difference between taking of the credit and availment of the credit. Taking of the credit takes place in my books of accounts. Availment of the credit takes place after the self-assessment through my return, my lord. So, if the allegation was the department was that I have not claimed the credit in my books of accounts, then my lord, his opinion would have been right. But merely because of my furnished my return late, my lord, it cannot be said that I have not taken the credit, my lord. Kindly refer to, my lord, section 41 for once. Section 41 of the Act. My lordship has the book. I'll kindly refer to this book. One more. Section 41. availment of input tax credit. Every registered person shall, subject to such conditions and restrictions as may be prescribed, be entitled to avail the credit of input tax credit as self-assessed. So in his return, and such amount shall be credited to his electronic credit ledger. So the section 16 subsection 4 uses the word take input tax credit, where is it section 41 says ki you take after after self-assessment of the ITC, you avail the credit through the return to be filed under section 39. And my lord, my humble submission that I take credit in the books of accounts, I prepare my books of accounts, and then I file my return. My lord, this is supported by, my lord, the judgment of the Honorable Supreme Court, your lordship. My lord, kindly refer to page 106 of the compilation. My lord, I am reading out from paragraph 33. Only these three paragraphs I will read out, my lord. 33, 34, and 35, which will make my submission, my lord, very clear as to what the Honorable Supreme Court says about this. 106, paragraph 33. My lord, shall I read out? As per the scheme of the 2017 Act, it is noticed that the registered person is obliged to do self-assessment of ITC, reckon its eligibility to ITC and of OTL, including the balance amount lying in cash or credit ledger, primarily on the basis of his office record and books of accounts required to be statutorily preserved and updated from time to time. So, my lord, it clearly says that I am obliged to do self-assessment of and reckon its eligibility to ITC and OTL, means output tax liability and ITC, both as per my books of accounts, I recognize on self-assessment. That he could do even without common electronic portal as was being done in the past till recently pre-GST regime. As regards liability to pay OTL, that is on the basis of transaction affected during the relevant period. Transaction during the relevant period giving rise to taxable event. The supply of goods and services become taxable in respect of which registered person is obliged to maintain agreement, invoices, challans, and books of accounts which can be maintained manually, electronically. The common portal is only a facilitator to feed or retrieve such information and need not be the primary source for doing self-assessment. The primary source is in the form of agreements, invoices, challan, receipt of goods and services, and books of accounts which are maintained by the SSC manually, electronically. These are not within the control of the tax authorities. This was the arrangement even in the pre-GST regime while discharging the obligation and the concerned legislation. The position is no different in the post-GST regime, both in the matter of doing self-assessment and regarding dealing with the eligibility to ITC and OTL. Indeed, that self-assessment and declaration would be in any way subject to verification by the tax authorities. The role of tax authorities come at the time of verification of the declaration and the returns submitted filed by the registered person. Section 16 of the 2017 Act deals with the eligibility of the registered person to take input tax credit charged on any supply of goods or services or both to him, which are used or intended to be used in the course or furtherance of his business. The input tax credit is additionally recorded in the electronic credit ledger of such person of that. So, my lord, it says that first I take the credit, then additionally I record in the electronic credit ledger, and that is done how? That is by filing of the return, my lord. Then, my lord, it says the electronic credit ledger is defined in section 246 and is referred to in section 49(2) of the 2017 Act, which provides for the manner in which the ITC may be availed. Section 41(1) advises that every registered person be entitled to take eligible input tax credit as self-assessed in his return, and such amount shall be credited on a provisional basis to his electronic credit ledger. But the last paragraph which I am reading out, as aforesaid, every SSE is under obligation to self-assess the eligible ITC under section 16(1) and 16(2) and credit the same in the electronic credit ledger defined in section 2, subsection 46, read with section 49 of the Act 2047. Only thereafter, section 59 steps in, where under the registered person is obliged to self-assess the taxes payable under the Act and furnish a return for each tax period as specified under section 39 of the Act. To put it differently, for submitting return under section 59, it is the registered person who has to undertake necessary measures, including maintenance of books of account for the relevant period, either manually or electronically. On the basis of such primary material, self-assessment can be and ought to be done by the SSC about the eligibility and availing of ITC and OTL, which is reflected in the periodical return to be filed under section 59 of the Act. So, my lord, this is my short submission, my lord, that I have taken my credit in my books of accounts. There is no dispute about that in his so-called notice or in his, my lord, this order in appeal which has been passed against me, that I have not taken the credit in my books of accounts. Only allegation against me is that I filed my return late. And my lord, I am entitled to file my return late. I have to
No,
pay interest.
There is a procedure to accept the return beyond the time.
Yes, my lord, section 47 says
Rest
that
of
on
it-
payment of the late fees,
Late-
I can file my return late. So there is
See,
nothing.
Therefore, the interpretation is entitlement to take input tax credit and entitlement to
Avail.
avail the credit of eligible input.
They are two different, my lord, things. And my lord,
But
but
there are decisions on this point.
my lord,
there
the
are
only decision,
eight-
my lord, on my lord, there is no decision on interpretation of section 16(4).
No,
But
no,
my lord, there is a interpretation with where do I take?
there is a decision to, if my memory serves right, interpreting the words entitled to take and entitled to avail.
Yes, my lord.
Availment is different, entitled to. 16(4) deals with the contingency in respect of an invoice or a debit note which has been raised after the due date for filing the return.
Yes, my lord.
There is a decision, sir. I remember.
No, my lord, under GST, my lord, there is no decision, my lord.
No,
But
no,
your
no.
lordship,
Under VAT.
under VAT, there must be.
There are a lot
My
of
lord, there is a
decisions.
decision of your lordship, my lord, on analogous issue, my lord.
What analogous issue?
My lord, I will submit, my lord. My lord, here the case was, my lord, that there was a. My lord, kindly refer to page 3, my lord. My lord, kindly refer to this judgment to start with, page 1 itself. My lord, my lord, set out the dispute in this, my lord, in this matter in the brief. But the issue was that there was a delay in filing of the GSTR1 return, my lord. There was an error on the part of the supplier. So it affected the right of the buyer because it did not auto-populate as a GSTR2A, because GSTR, my lord, 1 is filed by the supplier. This is a sales return with respect to the invoice-wise details of the supplies he has made. And then, my lord, it is auto-populated in the portal of the buyer, which entitles him to take input tax credit. My lord, there was an error on part of the supplier to correctly file his GSTR1 return, and the timeline for correction, which is, my lord, which is identical to section 16. My lord, kindly have a reference to section 37, my lord.
Yes.
At 37. And your
The
kindly have,
proviso provides for extension of time. Proviso under subsection 1 of 37.
this is a amended
No,
provision, my lord.
Mr. Sharaf, what happened to your writ petition? Dismissed.
Which one?
What happened to your writ petition?
In this matter. No, my lord, in this petition, my lord, what has happened is that the entire amount of the tax, it was
No,
recovered.
what is the order which is
My lord,
imputed?
my lord, I have not been allowed any, my lord, the interim relief has not been granted to me.
Wow, how interim relief can be granted?
No, my lord, the difficulty is that the entire, because the second issue is that the entire amount of tax has been recovered. Even, my lord, prior to the filing of the appeal, my lord, an amount of 22,96,640 was recovered. Then, my lord, and another amount of 567,040 was recovered after filing of the appeal. And another, my lord, 285,128, I paid for the purpose of filing of the appeal, which is mandatory in terms of the law, 10% of the disputed amount. So as on date, against an, my lord, demand of 28,64,780, I have already paid an amount of 30,48,808, which is much more than the amount which, my lord, I am supposed to pay.
And now what are they trying to do?
My lord, they cannot, my lord, they have recovered more than me. So what they will do? I am at the receiving end in this particular case. So, my lord, my humble submission, my lord, is
There
that
are a lot of decisions under the VAT Act.
My lord, there is one decision of the Karnataka High Court which is in my
Okay.
compilation page, my lord, 91,
79,
page 91.
starts at 79.
Yes, my lord, it starts at 79, but page 91, my lord, paragraph 30, my lord. Paragraph 30, I'm reading out. Both the questions framed above, they are therefore liable to be answered in favor of the petitioner SSC. The claim of the ITC cannot be restricted or denied on the stated ground. Why it cannot be denied only because the ITC claim is not been made in respect of sales
This is a
invoices.
single
which are
bench.
not-
This is a single bench decision. The very same judge, when you are in a division bench in Madras High Court, has held.
Yes,
And I have also held in under the VAT Act that this is a, of course, availment of credit is a concession
yes, my lord.
regulated by the conditions.
Yes, my lord.
But that once you comply with those conditions,
Yes,
the right accrues
yes,
in
my lord.
favor of the dealer.
Yes, my lord.
That cannot be effaced on account of a missionary provision,
Yes, my lord.
the manner of filing the return.
Yes, my lord. That is
That-
what is stated in this particular
That
judgment.
is the proposition of law, settled law.
Yes, my
You
lord.
argue before the single bench.
My lord, this issue, my lord, this is a small issue, my lord, the lordship can decide this, my lord. Because, my lord, there are number of such issues, my lord.
Actually, sir, if you read 16.4,
My lord.
it is very clear, sir. 16.4 does not speak of, let us see 16.4.
It is with regard to the time frame.
Ah, yes.
My lord, this issue is not
Eligibility, 16 deals with eligibility and conditions for taking input tax credit. Subsection 4 says, a registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or services or both after the 30th day of November following the end of the financial year to which such invoice or debit note pertains or furnishes the relevant annual return. So suppose an invoice is raised after the 30th day of November, he cannot, he is not entitled to
Take input tax.
take
credit.
input tax credit. But here is a case, you are using this provision to deny him credit on account of belated filing of return. What is it, section 10, no? Which is that section?
my lord,
Section
No,
regarding what, my lord?
section
no,
41.
filing of return,
Filing of return, my lord, section 39.
39, sir.
Filing of return is section 39. Furnishing of return, my lord.
Subsection 6. That is by notification. No, which says that you can file it on payment of late fee.
Well, that is section 47.
47.
Hmm.
Levy of late fees. And my lord, there is no time limit restriction in section 47.
So you can't read 40, I mean, the time limit prescribed in 37 into 16.4.
No, we have not done so.
No, that's what the appellate authority says.
Lordship, my lord, we are traveling in a completely wrong premise. This is not the case of denial of ITC. This is the case of wrongful availment of ITC
On the ground of non-filing of return.
No, in order to discharge his net output tax liability. Lordship, may kindly, my lord, seize the order first of the adjudicating authority. My lord, that is why the Honorable Single Judge directed us to exchange affidavit in this matter. Page 84. And the judgments which has been placed before your lordship, my lord, these are not at all relevant because ITC is of course is right, and upon
complying
complying with the conditions, he can always
But,
avail ITC.
But
Yeah, judgments of ALD automatic, your lordship was referring to, my lord.
You file your affidavit, we'll advance the
My
hearing.
lord, what my request, your lordship, is that, my lord, I made all my arguments. And my lord, in this particular matter, my lord, why affidavit is not required, I would say that there is no dispute about
I'll
the
file
fact.
my affidavit
My
before
lord,
your
I
lordship.
have filed my return
Lordship, may
late.
kindly hear out the matter whether he is entitled,
Sir.
because this is wrongful availment of ITC.
No, my lord,
I have
Wrongful availment
Hmm.
on the ground of belated filing of return.
intentional belated filing of
Then
return.
the statute provides for a penalty for that.
Pe-
But it doesn't mean that his return, he cannot avail input tax credit.
No, he can always avail input tax credit if he has filed it belatedly by
All right.
under section
Suppose
47.
he files the late fee.
My lord.
Then the return is deemed to have been valid
No,
return.
this was done to set off the output tax liability. That is what I am going to demonstrate to your lordship.
Obviously,
My lord,
see, once it is to his credit, that amount can be done.
I can file my item. Your lordship may ask me to
I
complete the
humble
pleadings
request,
here, my lord.
say
Your lordship
issue
may
of
kindly
interpretation,
hear
my
out the matter
I
here.
cannot argue any further, my lord. My learned friend can also only to the extent whether my delayed filing of the return can, my lord, my disentitle me to from
And my lord,
claiming
and my
of the
lord,
credit. There
my
is
lord,
no,
this the
there is
judgment of
nothing more,
RT
my lord, which can come
Atel,
in the
and
affidavit,
that is
my
the
lord.
judgment of Radhakishan Industries also. My lord, I'll place it before your lordship that these persons, my lord, there is two aspects of the matter. I have, in spite of being diligent, I have not been able to file my return within the due course. So I am always entitled to pay the late fine under section 47 and make the payment. And the other aspect is that I have declared that this is my ITC, though was not entitled to that. I have intentionally, belatedly not filed the return in order to set off the output tax liability.
All right, you file your affidavit, we'll hear it.
Your lordship may go.
We'll be heard so and so. The respondents are directed to file their affidavit in opposition within a week from date. 1 week,
Kindly grants, because I am junior less.
within 2 weeks from date. Reply if any within a week thereafter.
My lord, I will not require any
No
reply.
reply. Within 2 weeks from date. So we are 23rd. List the matter. You give a date and 14th. 14/7.
14 July. Great.
There are decisions under VAT. Sir.
Yes, my lord, I will.
There has been a recent decision from the Karnataka High Court by the Honorable Supreme Court with regard to ITC, my lord.
No, that is on a different
Karnataka VAT
footing,
Act.
whether, my lord,
Karnataka VAT Act.
there, my lord, the Honorable Justice M.R. Shah said that just by submitting your invoice and bank challan and all that, you cannot say that you are eligible for input tax credit. You have to show the movement of the goods also. That was a different issue altogether. That was a fake claim of ITC for non-existent from non-existent. So the issue was entirely different.
But it has also been decided under what conditions you can avail the ITC, and
there is no quarrel, sir. There is no vested right. It is a concession that has already been settled.
It is already been settled
by the Supreme Court. It has been settled. He needs to comply with 1, 2, 3, 4, 5, all
these conditions.
Those conditions. And if he does so, here it is not the case of the revenue that he has not complied with, but he has belatedly filed his return. So whether he will be able to avail the input tax credit on account of, whether he can be prevented from availment of the input tax credit merely because on account of belated filing of return. If the belated filing of return is a pardonable sin,
my lord, then we should have always pardoned, because we go in favor of the SSC. My lord,
so
because
date back to the
my lord, as it fell from your lordship, my lord, availment and utilization, it has been utilized for a purpose to set off the output tax liability, which I will demonstrate before your lordship.
Entitled to take, entitled to avail. That is the only distinction.
Yes, ma'am.
Entitled to take means if the invoice is beyond the due date,
yes,
that's 30th November, he cannot take. Taking means he takes it and puts it in the electronic cash,
electronic credit ledger.
And one credit ledger, sorry. From the credit ledger, he can adjust it for his output tax liability.
Right.
So if the invoice is beyond time, he cannot do that exercise because it is a self-assessment procedure.
Right.
Not under the
it is always
self-assessment. So he assesses himself But if consciously, if the invoice is beyond 30th November, that cannot be condoned.
Well-
But a dealer, if he files his return beyond the date, it can be condoned subject to
It
condition.
is always there because section 47 is standing at that.
So
Huh.
this right cannot be denied because of a machinery provisions.
Yes, ma'am.
All right, let us see.
Great for your lordship.
No, next one.
Serial number 8.
Yes, my time.
And you wanted restoration of the ITC.
My lord, my humble submission, my lord, I will make my submission, but before that, my lord, I wish to point out one thing, my lord. That, my lord, I had two prayers, my lord. Now, one prayer, my lord,
Is
allowed.
granted.
Another prayer rejected. My lord, it can be rejected, my lord, subject to the, my lord, whatever learned court feels, they can, my lord, the court can reject, always reject my prayer. But the thing is, my lord, that at least opportunity of making submission, why I have made that prayer, I may make a absolutely absurd prayer, and my lord, it may have no merit, my lord, but whatever may be my submission, and my lord, there are judgments of the Supreme Court that even read court, my lord, they have to record some reason as to why my prayer has been rejected, my lord. There is no recording of even, my lord, even a submission where we were not allowed to submit. My junior was there, my lord, that day I could not appear. So, my lord, at least there should be an opportunity of making some submission, my lord, that this is the submission and this is the reason that my prayer is rejected.
Then you file a review.
My lord, I would not go into filing of the review. I will meet the same fate, my lord.
No, where is, see, now some investigation is commenced. They were dragging the matter, then you said you have to complete it. And direction has been issued to conclude the investigation. Of course, no time limit has been fixed.
No, my lord, I will submit, my lord. What is why I am seeking refund, my lord? I will make submit, my lord, kindly allow 5 minutes. But the issue is that under the GST Act, but suppose I am a fraudster, my lord, I have committed all sorts of fraud, my lord, I have availed ineligible input tax credit. Section 74 says that even if I have availed a credit with fraudulent intent, I am entitled to a so-cause notice, my lord. Now that so-cause notice has to be adjudicated. On adjudication, my lord, I have a right to file appeal on payment of the 10% of the disputed amount. But because of this particular provision, my lord, there are judgments, my lord, from the erstwhile era also under the central excise, that whenever any recovery is made without, my lord, following the due process of law, that is issue of the so-cause notice and adjudication, any amount which has been recovered has to be refunded, my lord. And there are 3 judgments of the different honorable high court in the context of GST, that whenever such recovery has been made, it has to be refunded. And my lord, considering the judgments which were arising from different high court, my lord, in 2022, that is of course prior to this, but circular is always a clarification. Circular took note of this particular fact that a coercive recovery or a recovery in the course of the search seizure operation is happening. And my lord, the circular said that such situations should not arise and adjudication is a must. My lord, I place on record, my lord, those judgments also, and as well as, my lord, prior to that, the circular, my lord.
No, according to you, the investigation is still on.
It's still on, my lord.
And
So,
in the meantime, they recovered.
my lord, in the meantime, my lord, what is happening, my lord, all across the country, my lord, because of this provision under
Forget
section.
about the country.
My lord, I am talking about this only. My lord, section 132 is there. There is a power to arrest. My lord, by threatening that, my lord, they can put up any figure that you have evaded so and so. These your suppliers are fake. They are non-existent. They don't need to supply any document to me why they consider such and such supplier fake. And all this happens in the course of someone or search or seizure proceeding, which either their team comes to my place, which has happened in this case, that a search seizure operation happened. Someone happened from time to time, and it is going on and on. From time to time, they say that such and such supplier is fake. This supplier is fake, that supplier is fake. So, my lord, my humble submission is that let them issue me a so-cause notice. If they say that my suppliers are fake, this supplier, that supplier, whichever supplier is fake, let them issue so-cause notice, my lord. In the meanwhile,
Where is the recovery proceeding?
My lord, I will, my lord,
Not at all, my lord, any recovery proceedings. They have deposited the amount voluntarily. Now
No,
today
that
they
is
are
what-
saying
that
that,
is always
today
happens,
they are saying that that has been coercion.
that is always happening.
He has
my lord, that
deposited
we will-
and
No.
from the person who has taken the ITC, my lord, he has admitted that person is not reversing and that's why he has reversed the amount, my lord. Kindly see page 7 of
My
the
lord, allow me to
application.
submit, my lord, my learned friend always gets the opportunity. My lord.
Within 2 minutes, we can conclude. Very good. We will direct the investigation to be completed in 3 weeks.
My lord, kindly have a look at the jurisprudence on this. My lord, kindly keep it next week. my lord.
Jurisprudence is right. See, this is like putting the cart before the horse. But the circular dated 25th of May 2022, which you are referring, also says, however, the law does not bar the taxpayer from voluntarily making a payment of any tax ascertained by him or the tax officer in respect of such issues, either during the course of such proceedings or subsequently. Page
No, my lord,
63
but my lord,
of the writ petition, you have extracted the circular.
yes, my lord.
So now investigation, we will direct them to complete it within 3 weeks. And thereafter, they will issue show cause notice. There it let it be adjudicated whether this was voluntary payment or recovery without notice.
No, my lord, my lord, there is one more judgment of Delhi High Court, which says that once suppose I have made a voluntary payment also, but they are that is.
For we to adjudicate that, we can't put him in the dock and say whether he has voluntarily paid or not. So therefore, we will ask them to conclude the investigation within 3 weeks and issue show cause notice.
My lord, your lordship will kindly see
Sir,
page
whether if
396.
he is a non-existing dealer,
Yes.
you may say because his registration was cancelled.
He, against that non-existent, my lord, we have issued show cause notice. We have arrested him. Investigate, my lord, the trial is on the
But
process.
how is the purchasing
My
dealer?
lord, he is the purchasing dealer. He has admitted that I have. Kindly see, my lord, page 396.
Suppose
Your
he-
lordship, kindly see 396. This is the fake transaction, only the paper transaction. Nothing.
That is
physical
what they
transfer.
always say, my lord.
Kindly see the page
We'll
396.
expedite.
Why they
And
have
I am
admitted.
not, my lord, I am not submitting on the merits of the case.
My lord,
my lord. I am
kindly
only,
see
my lord,
396
only with
once.
respect to the recovery which has been made
Now,
from
within
me.
what time you will conclude the proceeding?
My lord, at least 3 months time.
3 months.
My lord, 3 months time. Within 3 months, my lord, investigation will be completed and we will issue the show cause notice. At least 3 months. And they have themselves prayed for the time to submit the documents. Kindly see, my lord. Page 40408, my lord. Kindly see, they have prayed for time. 41, my lord. They are praying time, we will submit the documents.
Wrongly availed.
Kindly see,
That
my
is
lord,
in
page
2020.
419, my lord. 419. Regarding request for time extension for document submission.
That is only for 15 days, my lord.
Yes, maybe.
Not for 3 months.
That is
That
the
was-
February
This
20.
intra-court appeal by the writ petitioner is directed against the order dated 13/6/2023 in WPA 11335 of 2023. There were 2 prayers made by the writ petitioner. One, to conclude the investigation which has been commenced by the respondent department. And the second prayer is to refund the amount of cash which was deposited by the appellant. The learned writ court had allowed the first prayer and directed the respondent authority to conclude the investigation arising out of the search and seizure proceedings in accordance with law. So far as the second prayer to refund the cash deposited by the appellant, the learned writ court had observed that the said prayer shall abide by the final order to be passed by the authorities. Aggrieved by that portion of the order, the appellant is before us by way of the present appeal. It is the contention of the appellant that even without issuing a show cause notice, amount has been recovered, which is against the well-settled principles of law. And therefore, the amount which has been recovered has to be refunded or recredited to the appellant's account. The learned senior standing counsel appearing for the respondent authority submitted that it is not a case of recovery, but it is a case of voluntary payment. And the Central Board of Indirect Taxes and Customs has clarified the same in the instruction number 1 of 2023, 2022-23 dated 25/5/2022, wherein while stating that there may not arise any situation where recovery of tax has to be made by the tax officer from the taxpayer during the course of search, inspection or investigation on account of any issue deducted during such proceedings. The circular further clarifies, however, the law does not bar the taxpayer from voluntarily making payment of any tax liability ascertained by him or the tax officer in respect of such issues, either during the course of such proceedings or subsequently. Thus, the disputed question would be whether the tax was recovered or whether the taxpayer had voluntarily made the payment. This disputed question cannot be adjudicated in a writ petition. Therefore, we are of the view that the investigation which has been commenced should be concluded at the earliest, and show cause notice should be issued to the appellant so that the appellant will be able to put forth their grievance by way of a reply. It is pointed out by the learned senior standing counsel for the respondent that by representation dated 2nd February 2023, the appellant had sought for extension of time for submission of documents. This letter is shown for the purpose of demonstrating the conduct of the appellant, who appears to be cooperating with the investigation, with the ongoing investigation. In the light of the above, the appeal stands disposed of by directing the respondent authorities to conclude the investigation within a period of 3 months from the date of receipt of the server copy of this order. In the meantime, the appellant shall submit all documents, and if necessary, a written representation can also be made before the investigating authorities. After considering all the matters, the investigation shall be concluded and show cause notice should be issued to the appellant. While replying to the show cause notice, it is well open to the appellant to raise the issue with regard to the refund of the cash, which according to the appellant was recovered and not voluntarily deposited. The adjudicating authority shall adjudicate this issue also among several issues that may arise in the show cause notice. The adjudication proceedings shall be completed as expeditiously, preferably within a period of 3 months from the date on which the appellant submits his reply to the show cause notice and is heard in person.
My lord, there is just one thing. My lord, your lordship in the first part of the order is directed to be concluded within 3 months. Then in the second part, your lordship has said that after
that.
submission of the reply, 3 months to pass the order. My lord,
Adjudication order.
adjudication.
My lords, one indulgence, my lords. There was one circuit bench matter, my lords, fixed today.
Where
Will
is it?
it be taken up, my lords? It was not called, my lords.
It is not there.
Only one item, my
And
lord.
who appears for the respondent?
I am not sure, my lords. I have served them.
GST matter.
GST.
I appear for the state.
And what is this matter?
My lords, it's against detention order, my lords.
This is
129,
vehicle being detained, my lord.
Vehicle detail.
vehicle detained, my
But
lords. Penalty.
What was it carrying beetle nut?
My lords, this will take much time, my lords.
they have challenged
My lords,
the
you may
position of
fix it
cess and
anytime.
everything.
Next time means July.
My lords?
July.
No, my lords, I am seeking for interim relief, my lords. My prima facie, the single bench has held in my favor, my lords.
Interim relief has been granted also by the Hon'ble single.
But I'm not satisfied with that, my lords. My only submission is that, my lords, there is no scope for improving their case, my lords. My lords may fix it anytime, my lords. I'll come and address you, my lords.
Next Friday.
My
But
lords.
next Friday,
my
my
lords,
lord,
today, my lords.
I'll be in some difficulty. But
Thursday,
your
Friday.
lordship has not declared, my lord, Thursday as a.
That will come.
My lords, today may anytime, my lords.
Today it cannot pass.
Monday, my lords, or any day, my lords.
You give some date.
Wednesday or Thursday, my lord.
Wednesday, my learned senior is.
From 3rd July, circuit bench is
That is
starting.
why, my lords, I am just seeking for slight directions, my lords.
Next week you give it.
Friday, Friday, I'm in difficulty. Wednesday, Thursday, any day. Thursday is a holiday.
Wednesday. Grateful, my lords. Thank you, sir.
Appellate side daily list fixed at 12 p.m. Serial number 1 and 2.
Appear for the petitioner. As a petitioner in the contempt application.
Yes, what happened?
Lords, after your lordship's order, on 21st of June 2023, when your lordships had been pleased to express not complete displeasure and not the prima facie observation as regards non-compliance of the order passed by your lordships on earlier occasions. Not it was expected that the election commission would try to carry out the order in letter and spirit, not and come out of its willful slackness.
Now what has happened now?
I am told yesterday in the evening, a further requisition was made at around 5 o'clock in the evening, and which is much less than the earlier force, not as was contemplated in the 2013 situation. I just need to draw your lordship's kind attention to 3 parts of the orders. But if your lordships are having
That we remember, we'll ask the senior counsel for the election commission as to.
But there were 3 parts of the order to be complied with in my most respectful submission.
Yes.
Your lordship's expression of complete faith reposed on the commission on the first, not kindly recollect that on 9th of June 2023, when the the state election commissioner was included as a person in person, but your lordships directed us to remove his name. But we removed him from the array of parties in his personal capacity. There was a prayer for observer made on 13th of June 2023 with the appointment of a retired judge for the purpose of observing the procedure. Your lordships were pleased not to accept our prayers because not the statutory mandate requires a state officer to be an observer. Now, your lordship's desire was a free and fair election and purity of election. That was the express language used in your lordship's order and also upheld by the Honorable Supreme Court. The purity of election with a free and fair atmosphere. That was the consideration. And what was the essence of your lordship's order was time. There should not be loss of time. That's recorded in paragraph 48, page 29 of the first order. Now, we moved the court on 9th of June 2023, the first available day after the date of declaration of election. Today we are on 23rd. "14 days have elapsed in the meantime. There are another 14 to 17 days left for the election, polling day. So the first order had observer issue,
Second issue was with regard to deployment of personnel. Third, with regard to CCTV and videographing. Fourth was redressal of grievance. And fifthly, no contractual and NCC employees below the would be deployed for the level of fourth polling officer. Now, kindly have a look at your lordship's order, the second order, which forms the subject matter of the contempt application. Page 31, paragraph 3. And I am showing to your lordship not how the trust and confidence reposed on the commission by the court has been irretrievably forfeited. Page 31, paragraph 3. The last two lines on that page. Till the writ petition was filed and heard in the moving session, the State Election Commission had not requisitioned the deployment of the central forces. If that be so, should the action of the State Election Commission be considered to be a deliberate violation of the order and direction issued in the earlier writ petitions? This issue is not gone into for the present. So, this is the first circumspection expressed by your lordship's court. In note paragraph 11 at page 37.
Yes.
Mr. Mitro, learned senior advocate appearing for the commission, assisted by so and so for the State Election Commission, page 37. Placed before this court the minutes of the meeting convened by the State Election Commission on 9th June 2023 with the Chief Secretary Government of West Bengal and Director General of Police West Bengal, and submitted that the necessary arrangement have been made to comply with the directions of the court, and it may take a few days to identify the sensitive areas. Then note paragraph 12. Ms. Sinha handed over the copies of letters written by the State Election Commissioner dated 14 June 2023 addressed to the Chief Secretary Government of West Bengal, stating that in the light of the order passed by the High Court, the Chief Secretary was requested to submit an assessment plan to deploy central forces for the ensuing election at the earliest so as to enable the Commission to take further necessary action in the matter. Copy of the letter addressed to the State Election Commission on 15 June 2023 was also placed before the court regarding the instructions issued by the Commission. Pausing here for a moment, your lordships have repeatedly laid down the law. If the state is not cooperating with the Commission for the purpose of conducting an election, it is for the Commission to approach the court. But that was the law laid down in 2006 also. But I am not on the 2013 situation either at this time, for the time being. After we have, paragraph 13, after we have elaborately heard the learned advocates for the parties and carefully considered the materials placed by the State Election Commission, it is clear that the State Election Commission has not taken any proactive and diligent steps. Your lordship's court was desiring a proactive and diligent step to be taken with a view to implement the directions issued by this court. In its letter and spirit, we say so because in the minutes of the meeting of 9 June 2023 convened by the Commission with the Chief Secretary and the DG of Police, with regard to identification of the sensitive areas from law and order point of view, it has been stated that the DM and SPs have initiated the process of identification of sensitive areas from law and order point of view. Now, I'm not kindly turns over the page. Kindly takes note the sixth line from the top. The sentence beginning from the middle portion of the line with the words, thus it is seen that more than 5 days, no action had been initiated and no assessment plan has been submitted to the Commission, which clearly shows that there is a slackness on the part of the administration in promptly reporting by identification of sensitive areas from the law and order point of view. So, the desire of the court to show proactiveness is not borne out from the materials placed on record, and your lordships are persuaded to hold that the action of the Commission clearly shows slackness on the part of the administration. And all these in the teeth of the observation that time was the essence of the order. Now, on the part of the administration in promptly reporting by identification of sensitive areas from the law and order point of view. In fact, it is the submission made on behalf of the Commission today that it may take a few more days for the identification of the sensitive areas. This, in our view, is not appreciable because of the fact that today is the last date for filing of nominations and the next will be a crucial event where the last date of withdrawal of nomination have been fixed. I mean, we are considering this order in its letter and spirit. Then, but forthwith requisition direction was there. Kindly text now, not paragraph 16, not which weighed with the Honorable Supreme Court heavily. At page 41. In the light of the observations in the preceding paragraphs and also taking note of the fact that no appreciable steps have been taken ever since the order was passed in the earlier writ petitions, and till date no effective steps have been taken to identify sensitive areas from law and order point of view, and in the light of the submission on behalf of the Commission that it may take a couple of more days to do so, we are of the view that waiting any longer will cause more damage to the situation and will not aid in protecting the purity of the election process. In the result, this writ petition is disposed of by directing as follows. So, not three things not come out from these orders. One, time is the essence of the orders. Number two, free and fair election. Number three, purity of the election.
Yes.
Things don't stop here. Kindly have a look to the Honorable Supreme Court's order, not when your Lordship's order is not quoted while being upheld. Page 9 of the order.
We gave it on the last day, but
Yes, yes, it's
I've
available.
given another copy, my lord, my lord. need
In the front.
আচ্ছা পেয়েছেন যত তো
কিশোর দাগে
ক্যাপ্টেনকে না দিলে হবে
Page 9.
You give that. Supreme Court. Page 9.
Page 9. Kindly have a look at the second line from the top of that page. It is in the above background that the direction was issued to the State Election Commission to send the requisition for deployment of the central forces in areas which, in the opinion of the State Election Commission, had been declared as sensitive forthwith. Therefore, we find that it was directed in the earlier order that there must be identification of the sensitive districts. But bearing in mind the fact that the State Election Commission had not complied with the earlier directions of the High Court in identifying the sensitive areas, we find that the High Court was left with no option but to direct the State Election Commission to requisition the deployment of central paramilitary forces for the entire state. When the observations in para 16 of the impugned order dated 15 June 2023 are viewed in light of the earlier order of the High Court not being complied with, we do not think they are unjustified. In fact, the directions issued by the High Court must be viewed from the point of view of the electorate of West Bengal, who should be enabled to exercise their franchise in a free and fair manner and not be in fear of the safety of their life and property. Kindly skips over the 3 lines of the next paragraph. Moreover, the state is conducting local body election on a single date. The High Court has also based its decision after considering the number of seats which are going to the polls and the volume of polling booths that are being set up for holding the said polls. Kindly turns over to page 11 now. The 5th line from the top of that page. 4th line. Therefore, in our view, the High Court was not in error in issuing the aforesaid directions, as the same was done to ensure not only that the nominations are filed in a peaceful manner, but also that the entire election is conducted fairly and the results are declared peacefully. Now, your Lordship's desire was from the stage of nomination, not the observation is there in the first order, nominations, withdrawal, all these things were taken into consideration, forming the basis for the loss of time being taken care of, with immediate proactive steps to be taken by the commission, which ultimately resulted in irretrievable forfeiture of the trust and confidence which the Court of Justice reposed on the commission. And that's reflected in the last order passed by this Honorable Court on 21st of June 2023. And I'll just read two sentences from your Lordship's last order. Sir. At page 3. Page 3, paragraph 3. আগের অর্ডারটা After elaborately hearing the arguments of the learned counsel for paragraph 3, for the parties, we have no hesitation in our mind to hold that the order and direction has not been complied with in its letter and spirit. We fail to understand as to why the State Election Commission is still not taking any independent decision in the matter, and the learned senior counsel for the State Commission on Instruction stated that the Election Commission will abide by the directions issued by this court. In the first order passed by this court, the court reposed confidence on the State Election Commission and directed to make an assessment of the sensitive districts, but we found that this direction has not yet been taken and the matter was being dragged, which necessitated the court to issue direction for deployment of the central forces for the entire state, which order has been also affirmed by the Honorable Supreme Court. On instructions, the learned senior advocate for the State Election Commission submitted that one company of the central forces, but I need not trouble your Lordship with the number of personnel. Lordship may straightway come to note the 8th line from the bottom of that page, beginning with the sentence beginning with the words, if that was the manner after the 2013 Panchayat election was considered. If that was the manner in which the State Election Commission had acted in the year 2013, we are at a loss to understand as to what has happened to the independence and supremacy of the State Election Commission during the ensuing election. In the said order of the Honorable Supreme Court, it has been recorded that the Panchayat election 2013 was to be conducted in 5 phases from 11 July to 25th July 2013. And interestingly, deployment of state police force was 1,05,000 and central forces was 82,000. And more particularly, at the relevant point of time, there were only 17 districts in the state of West Bengal, as against 22 districts at present. Therefore, if the State Election Commission is not proactive and not inclined to implement the order passed by this court in its letter and spirit, we are of the prima facie opinion that the State Election Commission is attempting to make the orders passed by this court unworkable, to which they are not entitled to, more particularly when the Honorable Supreme Court has affirmed the order. This will also lead us to a prima facie conclusion that there has been deliberate violation of the order and direction which was directed to be complied with in its letter and spirit in the light of the submissions made by the learned senior counsel for the commission, and the commission will abide by the directions issued by this court. We are inclined to issue the following directions which are ancillary and supplementary to the orders passed in the earlier 2 writ petitions. The State Commission shall within 24 hours requisition sufficient number of central forces to be deployed to all the districts, and the number of battalions which are to be requisitioned shall not be less than the forces which was requisitioned for the 2013 election, and it has to be definitely more than the same as the number of districts have increased, and the electorate would be definitely increased between 2013 and 2023 in these 10 years. Therefore, we expect that the State Election Commission to take note of this direction in a proper and effective manner, and this court hopes that the direction will be complied with in its letter and spirit, and any attempt to make the order unworkable may result in adverse consequences. But it's the final caution, not in my most respectful submission, given to the commission. Then not kindly sees not paragraph 5, which makes a more distressed and not awful reading of the conduct of the authorities. It is pointed out by the learned counsel for the petitioner that in the special petition filed before the Honorable Supreme Court, a copy of the letter addressed by the Additional Chief Secretary, Home and Hill Affairs Department, Parliamentary Affairs, to the Principal Secretary, Department of Home Affairs and Justice, Government of Punjab, dated 12th of June 2023 was annexed. On going through the letter, we are surprised to note that the requisition which was made to the Government of Punjab was to provide police force to reach the designated location by 6 July 2013 morning. Then not Your lordship has been please turn over to the next page. Or the last line of that page. Surprisingly, the sentence beginning from the extreme right-hand side of the line.
Yes.
Surprisingly, the instructions given to the learned senior counsel for the State Election Commission is contrary what has been written by the Additional Secretary to the Government of West Bengal to the Principal Secretary, Department of Home Affairs on 12 June 2023. This also appears to be an attempt to mislead the court, as the court, even in the order passed in the earlier repetition, had made it clear that the requisition of the central forces was to cover the entire election process, not on the date of polling alone. Therefore, we are of the view that such deployment of the forces from other states to be in place on the date of polling will not yield the desired result. Therefore, rehearse the number of police forces which may have been requisitioned from other states. The State Election Commission shall independently assess the requirement, and as observed earlier, the assessment should be honest and bearing in mind that the State Election Commission has constitutional obligation to ensure free and fair election and to preserve the purity of the entire election process. So it's not only free and fair, but also the purity of the entire election process. And when not the materials placed on record before your lordships clearly point at loss of or not lack of independence, lack of proactiveness, willful slackness, coupled with not the action of 12 June 2023, as expressed by the government of West Bengal, I am sure your lordships will be more than persuaded to hold that this has been a deliberate attempt to sidetrack your lordship's order, for which further ancillary orders are required to be passed. It's common knowledge, not even yesterday or day before yesterday, the court had to observe that the video was aiding a particular political party. There has been withdrawal of 5,000 nominations. A foreigner has submitted a nomination.
Staying in Saudi.
These are glaring facts which the court cannot lose sight of.
We will hear the commission what they will have to say.
I just renew my prayer. Kindly have a look at your lordship's first order. On 13th June. On 9th June, we from the array of parties we struck off the State Election Commissioner in his personal capacity. Please have a look at paragraph 41 of your lordship's order at page 22. By tinkering with time, the essence of your lordship's order has been gravely undermined. Paragraph 41 at page 22. The next issue is with regard to the appointment of observers. The State Election Commission has submitted that it appoints observers from senior officers of WBCS executives and IS cadres, and the appointment is made following the stipulation in section 134 of the Act, hereinafter so and so. This response is to the prayer sought for by the writ petitioner in WPA to appoint a retired judge of this court as an observer to ensure conduct of free, fair, transparent and peaceful election to the 3-tier Gram Panchayats in the state of West Bengal. Section 134 falls in chapter 16 of 2003 Act. Subsection 1 of section 134 states that the commission may nominate an observer who shall be an officer of the state government to watch the conduct of election or elections in the constituency or group of constituencies and to perform such other functions as may be entrusted to him by the commission. Subsection 2 states that the observer nominated under subsection 1 of section 134 shall have the power to direct the Panchayat returning officer for the constituency or for any other constituencies for which he has been nominated to stop the counting of votes at any time before the declaration of the result or not to declare the same, if in the opinion of the observer, booth capturing has taken place or at a large number of polling stations or at places fixed for counting of votes of many ballot papers used at a polling stations are unlawfully taken out of the custody of the Panchayat returning officer or are accidentally or intentionally destroyed or lost or damaged or tampered with to such an extent that the result of the polling at the polling station cannot be ascertained. Subsection 3 of section 134 states that where an observer has been directed, the Panchayat returning officer to stop counting of votes or not to declare the result, the observer shall forthwith report the matter to the commission and thereupon the commission shall, after taking all material circumstances into account, issue appropriate direction. Thus, the statutory provision clearly provides for nominating an observer by the commission who shall be an officer of the state government to watch the conduct of the elections, the State Election Commission in its report has stated that the commission appoints observers from the cadre of senior officers. I'm sorry.
Please carry.
From the cadre of senior officers of the West Bengal Civil Services and IAS cadres. In our opinion, the exercise to be done by the State Commission being in accordance with the statutory provision, the court will not be justified in interdicting the same, as the senior officers of the West Bengal Civil Services as well as the officers in the IAS cadres are bound to act with due diligence, bearing in mind the purpose for which they have been nominated as observers. Now, please take the last 5 lines of that page, particular page. But I need not trouble your lordship with the rest of the paragraph note, which may not be very necessary for our purpose at this stage. Therefore, we are of the view that your lordships have kindly got that the appointment of observers from the senior officers of the West Bengal Civil Services executives and IAS cadres is in consonance with section 134 of the 2003 Act, and the same would be sufficient safeguard to achieve the object for having free and fair elections, maintaining its purity. Therefore, we see no reason to accede to the prayer sought for by the writ petitioner to appoint a retired judge of this court as observer for the ensuring election. So, my lord, with the passage of time and my lord, the conduct gleaned from the action or my lord, the materials available on record, it is clear that the independence and supremacy of the commission has been surrendered for any unholy purpose. And my lord, I am not mincing any word for this purpose when I am advancing my submission. The essence of time, the spirit of the order has been frustrated. Number one, your lordships have been more than persuaded to hold that the supremacy and independence of the commission has been surrendered or is questionable. Your lordships have been prima facie pleased to hold that the commission is guilty of contempt for sidestepping your lordship's order in letter and spirit. And the authorities have misled the court. When your lordships were persuaded to repose trust and confidence in the first order of 13th of June 2023, your lordships were misled. So the changed circumstances encourages me to renew my prayer, even if it is not through a retired judge. It's common knowledge. His Excellency, the Honorable Governor, is not accepting his joining. Not only by the highest judiciary of the state, but also the executive head of the state is not reposing confidence. But are we to sit tight as mere onlookers? But I am renewing my prayer insofar as appointment of observers is concerned.
The order is complied with, observer.
Yes.
The order is complied.
But the purity of election is one of the essential factors which had been taken note by the judiciary. Free and fair election and purity of election. This purity of election has been compromised at the behest of the commission. And there are sufficient reasons to be indicated in the last paragraph page of your lordship's last order in the contempt jurisdiction. This is one aspect of the matter. So far as deployment of forces is concerned, the election commission, the state and the center is before your lordship's court. Today, with the passage of time, with the uncanny situation which prompted withdrawal of 5,000 nomination on one particular or 2 or 3 particular days. I can give the list of the political parties who have been forced to. 40,000 nomination submitted on a particular day for the ruling party in dispensation, and 5,000 nomination withdrawn.
In 1 hour.
Within 1 hour, 40,000 nominations submitted.
They submitted extra and withdrew it.
Somebody from Saudi Arabia had filed the nomination. That's in the court's jurisdiction now.
The order passed. That is not.
Court has passed orders.
We are not getting that, or it's not uploaded. File can be repeated. WP number দিয়ে দিচ্ছি আমি 1481 আবার চেক কর
20,585 withdrawal in 3 days.
Yes.
Essence of time not was the, sorry, time was the essence of the order, and which they have not successfully eroded. With the questionable conduct of the commissioner, with the complete forfeiture of trust and confidence which the court reposed on the commission, I submit, there should be an appointment of an observer, number one. Number two, so far as conduct of election is concerned, your lordships may also consider the 2013 situation when the court directed, not because of non-deployment of forces in 5 phases or on 5 days, the lordships may reconsider the issue. These are my submissions.
Yes. Yes.
Now, my lord, we are in a contempt jurisdiction. Now. I cannot say that I'm not going to obey the orders of the court. My lord, my learned friend's client has certain grievances which is brought to the notice of the court as an informant to the court. My lord, today the final submission is that observers are required to be appointed by this court. But I'll come to that later on. My first submission would be, my lord, on the contempt aspect. My lord, the final order in the series of order has been passed by the Honorable Supreme Court prior to the last order of this Honorable Court. But please have a look to this order, my lord, which my learned friends have handed up to the court. Yes. My lord, please take the third page of the order. But these are all, my lord, quoting my lord's order initially. Please take the third page of the order, but after the quoted portion. Thus, by issuance of the aforesaid direction, the State Election Commission was directed to requisition the deployment of central forces, and the direction was to be complied with within a period of 48 hours from the receipt of the copy of the order. There were other orders on 9th of June and 13th of June. Then, my lord, the Honorable Supreme Court, my lord, quotes those orders. Then please take, my lord, page 6. Learned senior counsel appearing for the State Election Commission as well as the State of West Bengal contended that direction for requisition of the deployment of the central forces for all the districts in the state of West Bengal was wholly unwarranted, and therefore the same ought to be interfered with by this court. More particularly, the learned senior counsel, Mrs. Meenakshi Arora, contended that it is not within the jurisdiction of the State Election Commission to requisition the deployment of the central forces for the conduct of election in the state. Learned senior counsel appearing for the state of West Bengal also submitted that no doubt there may arise a need for additional police forces for the conduct of a free and fair poll on 8th of July and for the processes leading up to the said date. However, the additional forces to be summoned or requisitioned is a matter within the discretion of the state government. The state government, in addition to the police forces already under its command, could requisition or plan to requisition the forces from the neighboring states. But the impugned direction, which has been issued by the High Court, has taken away that discretion, and hence he submitted that the said direction ought to be quashed. These are the submissions of the Commission and the state. Now, Mr. Harish Salve was representing my learned friend's client. Par contra, Sri Harish Salve, learned senior counsel appearing for the respondent number 1 on caveat, supported the order of the High Court and submitted that this is not the first time that the High Court has issued such a direction. Even on previous occasions, similar directions have been passed by the High Court in order to ensure that free and fair polls are conducted in the state. It was further submitted that in the instant case, having regard to the earlier directions issued by the High Court not being complied with by the State Election Commission, the observations at paragraph 16 were made, and therefore the consequent direction at paragraph 17 does not call for any interference in this special leave petition. Then we give our reply. Then please skip over the next paragraph, and the paragraph thereafter we have considered the submissions made on behalf of the rival parties and given our anxious consideration to each of those submissions. It is significant to note that members belonging to different political parties have voiced a common concern and had sought similar reliefs in the writ petition filed before the High Court. At the outset, we find that the order dated 15/6/23 for deployment of central forces for all the districts in the state of West Bengal has been preceded by earlier orders passed by the High Court, which we have referred to herein above. In the order dated 15th of June, the High Court has noted that earlier a direction was issued to the State Election Commission to review the assessment plan submitted by the state, and wherever there was inadequacy of the state police, the State Election Commission in all such areas was to requisition the deployment of paramilitary forces forthwith, and on receipt of such a request, the appropriate authorities of the central government were directed to deploy the required strength on charges to be borne by the central government. However, the State Election Commission failed to identify these sensitive areas, and as observed by the High Court, the State Election Commission has not requisitioned the deployment of central forces till the writ application were heard finally. It is further observed by the High Court that there was no due diligence in the implementation of the directions issued by the High Court in the earlier writ petition in its letter and spirit. Considering the sensitivity of the issue, the High Court noted that the State Election Commission had dragged its feet in not complying with the direction of the High Court, even though a decision was taken in a meeting of 9th June for identification of the sensitive areas from the point of view of law and order. In the light of the above observation, the High Court finally concluded at paragraph 16 as quoted above and issued the directions at paragraph 17 of the order. It is relevant to observe that it is not for the first time that a direction for deployment of central military forces has been ordered by the High Court. In paragraph 48 of the order dated 13th of June, there is a discussion on the earlier occasions in which the High Court had directed the deployment of paramilitary forces as and when the situation so demanded. It is in the above background that the direction was issued to the State Election Commission to send the requisition for deployment of central forces in the area, which in the opinion of the State Election Commission had been declared as sensitive forthwith. Therefore, we find that it was directed in the earlier order that there must be identification of the sensitive districts, but bearing in mind that the fact that the State Election Commission had not complied with the earlier directions of the High Court in identifying the sensitive areas, we find that the High Court was left with no option but to direct the State Election Commission to requisition the deployment of central paramilitary forces for the entire state. When the observations in para 16 of the impugned order dated 15/6/23 are viewed in the light of the earlier of the High Court not being complied with, we do not think they are unjustified. In fact, the directions issued by the High Court must be viewed from the point of view of the electorate of West Bengal, who should be enabled to exercise their franchise in a free and fair manner and not in fear of safety of their life and property. Fact remains that the tenor of the order of the High Court is ultimately to ensure that there is free and fair election conducted in the state of West Bengal. Moreover, the state is conducting local body election in a single day. The High Court has also based its direction after considering the number of seats which are going to the polls and the volume of polling booths that are being set up for holding these 8 polls. It is needless to observe that the central force would act in an appropriate manner, bearing in mind the emerging situations and for aiding in a free and fair conduct of the election. We further observe that portion I don't think is that relevant for our purpose. Kindly take page 11, the first paragraph. The endeavor of the respondents, writ petitioners before the High Court appears to be to ensure free and fair election to the local bodies in the state of West Bengal. This would strengthen Panchayati Raj institutions in the state. Therefore, in our view, the High Court was not in error in issuing the aforesaid directions, as the same was done to ensure Not only that the nominations are filed in a peaceful manner, but also that the entire election is conducted fairly and the results are declared peaceful. We also take note of the fact that the respondents hearing or the petitions with the High Court, although affiliated to different political parties, are united. Therefore, my lord, finally, my lord, the Supreme Court, my lord, on 20th of June, my lord, directs or my lord, dismisses the special petitions by upholding my lord's order.
Yes.
Now, my lord, on the issue of contempt, my lord, may I humbly submit, my lord, this order was delivered by the Honorable Supreme Court on 20th of June. My lord, on 22nd of June, hey, copy that. But the first page is the requisition from the State Election Commission to Ajay Kumar Bhalla, etc. Enclosed is fine with herewith communication from the State Election Commission regarding so and so. The next page, the letter is there. Panchayat elections have been notified in the West Bengal by the State Election Commission. The Honorable Calcutta High Court has ordered the State Election Commission West Bengal to requisition and deploy CAPF in the state reference. The commission accordingly approaches you to kindly mobilize 800 companies of CAPF for the state. The forces will report to the district magistrate and district panchayat election officer of the district. District-wise breakup are as follows. Breakup follows, I'm sorry. It may be noted that the current requirement is over and above the 22 companies already mobilized for the State Video Commission's communication dated 20th of June 2023. Therefore, my lord, as of now, 800 plus 22 my lord, companies of CAPF has been requisitioned. My lord, we are yet to, my lord, receive any response from the center.
Response has been obtained from the main check. 315 is coming, 315. As for, so there is a register of 485 companies, and for that also a requisition has been issued to the Ministry of Home Affairs today itself. I'm giving you the copy.
My lord, while my lord, this matter was going on, before the start of the matter, my lord, my instruction was there is no response. But right now, my lord, I'm told that out of 800 companies, 315 has been sanctioned, my lord. They may reach at any time. And so far as the balance, 485.
Letter has been issued from the commissioner today itself to the Ministry of Home Affairs.
Another letter has been sent while, my lord, this proceeding was going on today itself during the course of this proceeding for, my lord, releasing the balance 485 companies. So my lord, these are the figures, my lord, for your lordships, my lord, for the present. Therefore, my lord, I very humbly submit that, my lord, as soon as, my lord, our last persuasion was over before the Honorable Supreme Court, my lord, we have done it, my lord, within 48 hours. This is, my lord, so far as, my lord, requisitioning of the force is concerned. My lord, we are expecting the central government to, my lord, act in terms of your lordship's order, my lord. Thereafter, my lord, once they come, my lord, the deployment would be taken, would be made. Therefore, my lord, I would be very respectfully submitting, my lord, that in view of, my lord, the hierarchy of our judiciary and, my lord, our exercise of right, my lord, there is no willful delay on our part, my lord, in requisitioning the police force. I mean, the central forces. Now, my lord, on the apprehension,
Yes.
and my lord, I must also, my lord, say that, my lord, if your lordships would kindly consider that, my lord, there was no deliberate violation, my lord, on our part, and therefore kindly, my lord, drop the proceedings. My lord, this would be, my lord, my first submissions, my lord, in respect of the deployment aspect only.
Yes.
Now, my lord, on the other aspect that the free and fair elections are concerned, my lord, we can only, my lord, tell the court that it is our obligation and we would try to, my lord, to the best of our ability to, my lord, ensure that there is free and fair elections. My lord, the incidents which my learned friends have said, my lord, these are all incidents, my lord, which are being taken care of, my lord, in the adversarial side, my lord, where party or the persons who feel that they could not approach the court, I mean the nomination filing centers within time, or nomination has not been considered accordingly, my lord, they are pursuing their remedies before the appropriate court in the adversarial side. Now, my lord, on the aspect of observers, my lord, may I only say, my lord, one more thing, but I think, my lord, this figure should also be placed before my lord. My lord, as your lordships have been informed, my lord, in 2013, my lord, the elections were held in 5 phases. Now, my lord, in each of the phases, my lord, I think, my lord, we should give the number of, my lord, the central forces which were deployed. My lord, in the first phase, 15,000 were deployed.
Yes, that's there in the Supreme Court.
Yes, very well. So, my lord, I don't, my lord, repeat what is there before the Honorable Supreme Court. Now, my lord, on the other aspect which my learned friend says that, my lord, observers are to be appointed. But on that, my lord, I think, my lord, it is too premature at this stage to make this kind of a prayer. My lord, we are committed. We have got a constitutional responsibility, my lord. We are a constitutional body. The head of the constitutional body is having, my lord, all plenary powers, my lord, as have been held by the Supreme Court, by, my lord, interpreting the expression superintendence and control of election. My lord, we can, my lord, only tell this Honorable Court, my lord, that we will take all steps required, necessary, my lord, for free and fair elections, my lord. My lord, and so far as, my lord, the observers are concerned, I think, my lord, it is too premature at this stage, my lord, to ask for this. My lord, whatever were the apprehensions were, my lord, so long on the anvil of the anxiety to have the central forces. Now that the central forces are in place, my lord, we have abided by your lordship's order. So kindly, my lord, on the observers aspect, my lord, kindly, my lord, do not pass any orders, my lord. And if your lordships consider that it is required to be passed, but in that case, my lord, let my learned friends
appointed 273 observers from West Bengal Civil Service Executive Cadre and 22 officers.
under which power have we? 73 IAS.
73.
Only 22.
Special observers for the districts.
Excellent. Who's 273?
That's 22. 273.
WBCS.
Right.
আর এরা হচ্ছে IAS আর কি করেছি
বলা হয়েছে কোনো পর্যন্ত।
Yes.
But on the observers aspect, my lord, my instructing officer says that, my lord, we have already appointed, but I have to check up those provisions. But right now, I'll be very candid, but I'm not having those provisions with me. 273 WBCS officers, my lord, has already been appointed as observers, and 22 IAS officers have been appointed as observers.
These 273 are in group 1 officers.
Yes, yes.
What will be their cadre roughly?
The cadre group 1 officers.
WBC is institute.
Honorable to
Group B has two service. Combination of present there till the completion of conversion form 7 existing candidates. They have been there.
Well, these are all, my lord, class 1 officers.
Class 1.
And, my lord, their deployment is till the declaration of the results.
but there is no report, no affidavit on behalf of the commission.
My lord,
This contempt.
I'm sorry, my lord.
That is, we passed an order on 21st June,
Yes, my lord.
and pursuant to that, there is no report filed by the commission.
Before this court.
Yes. Before us,
I don't think so, my lord. I was not there. আমরা এখানে কোনো report file করেছি? My lord, we can file report. My lord. We have not filed a report as yet. My lord, with all these
but it should be in the form of an affidavit. So we'll frame an order now. We'll
But
see.
may I say this, my lord? I have got nothing to hide from the court. Whatever I give, my
No,
lord,
let it go on record. That's better.
very.
Because they have filed a contempt alleging willful delay.
Yes.
Now the explanation of the commission is post decision of the Honorable Supreme Court on 20th of June, we have complied with. But their submission appears to be the delay should not be computed from that date. The delay starts running from 13/6
Right.
from the first order.
Right.
So that is one aspect we need to consider. And then what about the other incidents? The thing is, we don't know, of course, obviously they should have a control room. They should have to monitor the entire activity throughout the state 24/7. Anything can happen. Nomination, how they have just been filed, periodic reports. We don't know what is the machinery you have set up, because even in the first writ petition, second writ petition, contempt petition, nothing has been disclosed to us. Except for one, we have in fact, in the first order, we have noted that in an unsigned, undated report was placed, which we took into consideration because submitted through a senior advocate along with annexures, we took it as. So that's been the stand of the commission. We don't know how the commission files. Even today, one matter in the other division bench, we have disposed it of directing the commission to look into the matter. In another matter, commission has been directed to submit a report on Monday, where there has been 275 seats. Nobody has filed nominations except one set of candidates, and it is going to go uncontested. What is that block? What is that block? Canning one block. So that we have said, and who has come to court? Not the candidate. The people who say I am the electorate, my right to choose a candidate is being lost. It is done in an undemocratic manner, etc., etc. So, speaking for myself, I have done such matters where what happens is, on a real-time basis, the commission is in touch with the standing council. Reports are being sent by email or in soft form, and they will say, this is my structure. That's how they are always on plain paper, but we don't know how the commission has been for. And we don't want to go into the other issue which he has pointed out.
Yes.
So we'll make an order. Let us see what happens.
My lord, kindly, my lord, not to be taken on record. But at one point of time, my lord, I had made an assessment as to in the panchayat, but what is the situation in the other part of the country? My lord, in many states, the statistics are in the panchayat rang, quite a large number of seats go uncontested. Because it is mostly within the village, people know each other.
I don't know whether they have all come to court, etc.
Yes.
Anyway, it may be a true or may not be true. We'll hear the additions also.
Yes.
Thank you.
But yesterday evening, the Home Secretariat had a discussion with me. Yes, I'm sorry. Yesterday in the evening, the Home Secretariat of Government of India had a detailed discussion with me. Firstly, they desired that the 2013 model may be followed, and if it is followed, that will be convenient for the Home Ministry to deploy the entire forces. Now, at night, I have received an instruction for perusal of your lordships. This is the instruction I have received. It is addressed to me personally, but it's an instruction. Now, lordships, kindly find from para 2, the deployment of forces in 2013. It has given a breakup and other things. Now, if my lords kindly come to the next page. Contra.
So the 315 companies
315 plus 22 already.
acquisition, and this will be more than 2030.
Yes, that has been reflected in para 2 of the instruction.
Yes, which is higher.
Para 3 of the instruction.
Para 6 also there.
Yes, para 6.
Para 6 it is clear.
Yes. Therefore, my lord, it is for your lords to decide on such, but this is the latest instruction.
This contempt petition, contempt application was filed.
And only one submission in reply. And your lordships have been pleased to observe in the last order that the
No,
requisition.
you please hear this order. Alleging willful disobedience of the order and direction issued by this court in WPA P 301 of 2023, dated 15/6/2023. The court also took note of the earlier orders passed in WPA P 250 of 2023, dated 13/6/2023. The operative portion of the direction issued in the order is as follows. Please quote para 6 of the order dated 21/6. The learned advocate appearing for the contempt applicant had elaborately referred to the various paragraphs of the order passed in WPA P 301 of 2023, dated 15/6/2023, the order dated 13/6/2023 in WPA 250 of 2023, and the order passed by the Honorable Supreme Court in special leave to appeal in special leave petition C number 12294 of 2023, dated 20/6/2023. It is submitted that a cumulative reading of all these three orders will show that the time was the essence of the orders passed by this court, and the other two aspects being conduct of free and fair elections and to preserve the purity of the election process. It is submitted that these were the broad parameters which had weighed in the mind of this court while passing the order dated 13/6/2023 and 15/6/2023, which orders have been upheld by the Honorable Supreme Court. It is submitted that the turn of events it is submitted by the learned advocate for the applicant that the turn of events will clearly show the supremacy of the State Election Commission has been surrendered, and the purity of the election process has been compromised thus far and is likely to be compromised further. Therefore, the learned advocate for the applicant seeks for renewal of the prayer made in the first writ petition, namely WPA 286 287 of 2023, wherein they sought for an independent observer to be appointed by this court, and it was suggested that such an independent observer can be a retired judge of this court. The learned senior advocate appearing for the State Election Commission had Election Commission after referring to the order passed by the Honorable Supreme Court dated 20th June 2023, submitted that on 22/6/2023 they have requisitioned the requisition, the 8,000 companies, requisition adequate central forces in addition to the 22 companies already requisitioned. And out of the same, 315 has been sanctioned by the central government, and the remaining will be also done shortly. Therefore, it is a submission that there is no willful delay on the part of the State Election Commission in compliance of the orders passed by this court. And a prayer has been made to drop the contempt proceedings. Further, with regard to the observers, it is submitted that 273 Class 1 officers of the West Bengal State Service and 22 IAS officers have been nominated as observers. And the officers will discharge their duties diligently. The learned Additional Solicitor General appearing for the Union of India on instructions submitted that that orders have been issued by the central government for deployment of 315 companies for the 2023 Panchayat election, which is higher than what is provided for what was provided in the 2013 election. After we have heard the submission for the on behalf of the learned advocates appearing for the parties, we are of the view that in order to decide as to whether there has been any willful non-compliance of the directions issued by this court in its order dated 15/6/2023, which in fact was ancillary and supplementary to the earlier order dated 13/6/2023, we are of the view that affidavit needs to be filed by the State Election Commission. A crucial question would be as to whether the submission made on behalf of the State Election Commission that there is no willful delay on the part of the Commission, as they have complied with the orders on 22/6/2023. Soon after, the special petition filed by them was dismissed by the Honorable Supreme Court on 20/6/2023. The question would be as to how the delay has to be computed. As observed in the order dated 15/6/2023, the said order was in continuation of the earlier orders dated 13/6/2023, in which also timelines were fixed. Therefore, the order dated 13/6/2023 for all purposes stands merged with the order dated 15/6/2023, and both these orders stand merged with the order passed in this contempt application dated 21/6/2023. Therefore, the court has to consider the cumulative circumstances to examine the conduct of the State Election Commission as to whether there was any willful disobedience of the order and directions issued from time to time, or was there any attempt to make the order unworkable at different stages of time. This issue cannot be decided without an affidavit being filed by the State Election Commission. So far as the direction issued to the central government is concerned, we find the same has been complied with pursuant to the requisition made by the State of West Bengal. And in the assessment of the Ministry of Home Affairs, 315 companies would be adequate, and it would be more than, and it is higher than what was provided in the 2013 election, which we had indicated in our order dated 21/6/2023. Needless to state, as emphasized by this court time and again, that it is the assessment of the State Election Commission which is paramount. In fact, the court used the expression that the State Election Commission should make an honest assessment. Therefore, if according to the State Election Commission, 315 companies as deployed by the Central Commission is is not adequate, but then the State Election Commission shall not fight shy to make additional requisition to the central government. This observation is made after taking note of the submissions made on behalf of the State Election Commission that the Commission will do all within its means to ensure free and fair elections and to preserve the purity of the election process. It was also submitted on behalf of the Commission that individual grievances are before this court, being heard and decided by the learned single benches. However, we had pointed out to the learned senior advocate appearing for the appellant that even today, before the regular court, there were 2 writ petitions which were filed as public interest litigations. And in one of those writ petitions, it was reported that 273 seats in canning one block have remain uncontested, and it is the voters who have come to court to say that they have got a right to choose the candidate, and a prospective candidate cannot be prevented from filing the nomination, and that the State Election Commission has not taken any proactive step in this regard. A direction has been issued in the said petition to the State Election Commission for their response. Given the totality of circumstances, and that not only the regular bench of this court, but two single benches and one another the division bench are all being engaged in matters concerning the elections concerning the ensuing panchayat election. Therefore, we are of the view that strict monitoring is required to be done in the matter, for which affidavit has to be filed, after which the court will consider as to whether there has been any willful disobedience of the order and direction issued by the court in all the 3 orders and such other matters. Full stop. With regard to the appointment of observers are concerned, since the court in its initial order, in its first order dated 13/6/2023, declined to accede such a prayer, and in the present proceedings, a prayer has been made to renew the said prayer, such a request can be considered only after an affidavit is filed by the State Election Commission in this regard. We expect the State Election Commission to answer to the prayer on merits without raising any technical objection in this regard, as we have observed that the orders dated 13/6/2023, as we observed that the orders passed by the court from time to time are incidental and ancillary to each other, and the object behind passing such orders is to ensure free and fair election and to preserve the purity of the election process. We direct the State Election Commission to file their affidavit covering all the above aspects by 27/6/2023. Let the matter be listed on 28/7/2023 at 2:30 p.m.
28/6/20. It has
Sorry, 6/6/6. 27/6,
28.
28/6, sorry, 28/6 at 2:30 p.m.
My lord, only one thing, my lord, if I may make submission, my lord. If I'm not, my lord, wrongly heard, my lord, we have already, my lord, requisitioned for 485 today itself in course of hearing.
Okay.
Kindly be required.
Mr. Dattu Leonard, senior advocate appearing for the State Election
sure.
Commission, submitted
Sure.
that he has been given instructions from the commission that while the hearing was proceeding in the matter, additional deployment has also been sought for.
Of those 485,
Uh,
822 minus 315, 485. For the 485, another letter has gone while the matter was going.
Another 485, what is it? Companies. Companies has been.
Or your lordship may kindly consider, my lord, the recording in this way. Balance 485.
The balance 485 companies have been requisitioned. This submission is placed on.
315 in addition to
Of CRP.
315 companies in addition to 22 already deployed. That has been to be recorded. And my instruction may be kept on record.
We have not specifically recorded that because it's a personal letter. But of course, the last line says, please inform the court.
Yes.
One more sentence. The learned additional Solicitor General has also produced the copy of the written instructions given by the director, within bracket, PERS, bracket close, Ministry of Home Affairs dated 22/6/2023, wherein it has been stated as follows. Para 3, 5 and 6. Oh, no, 5 up to 7.
And the instruction is taken on record.
Yes, the above referred written instruction is taken on record. It is part of the order deemed to have been taken on record. Yes. In between you add, sir. The learned advocate appearing for the applicant submitted that an anomalous situation has arisen, wherein large number of withdrawal of nominations have taken place, and the figure and the astronomical figure is 20585.
Oh, wow.
Full stop. The State Election Commission, while filing their affidavit, shall also address this aspect or this aspect of the matter, as in several cases this has been raised by various petitioners.
My lord, one more thing, my lord. I'm so sorry, my lord.
No problem.
My officer says that possibly, my lord, your lordships are of the view that observers would be appointed. In fact,
No. With regard to the prayer, he wants to renew the prayer. Without hearing you, we will not do that.
not on that aspect, my lord. The figure that I have placed before my lord, that WBCS and IS
Yes.
officers, they have already been deployed.
Yes, that we are.
Right.
So let it come next Wednesday.
Right.
My
Yes,
lord,
what
with
is
regard
the
to the
videography?
second contempt, my lord,
Yes.
the videography, shall I come back at 2 o'clock, my lord?
No, 2 o'clock is not possible. You please make use of.
Fair enough, my lord.
What is your instruction on that videographing, sir?
My lord, OTK appeal coach.
My lord, I am on a very limited point, my lord. Lord, will kindly take page 30 of the impugned order, my lord. Of the order, my lord, where, my lord, they are in
My
violation.
lord, may I only say one thing, my lord, instead of wasting your lordship's time, could this matter be taken up, my lord, maybe on Monday? In the meantime, may I take instruction? But the only instruction that I'm spontaneously got is that we have already written to whoever is concerned. But my lord, with half-baked knowledge, my lord, I don't want to, my lord, address the court. Kindly take it up as the first matter on Monday, or whenever your lordship feels, my lord.
But only
We just here is.
only thing is, well, lordship was pleased to observe, my lord,
with regard to videography, my lord, a specific submission was made on our part, my lord. That, my lord, where where CCTV coverage is not possible, videograph to be done
That is,
from the
we have
date of,
directed
yes,
in the first order.
first order, my lord. The second order, my lord, was assailed before the Honorable Supreme Court. Lordship will kindly take the
No.
last line of the
Supreme Court, both orders.
both orders. And the
Yes,
last
both
line, my lord, last line of that order, my lord, I will only take the second last paragraph, my lord. In the circumstances, we find that the order of the Honorable High Court would not call for any interference in these special leave petitions, and we are also not inclined to interfere with any other direction issues. So this direction which
Is
the Lordship,
affirmed.
that is covered.
That Mr.
That is
Dattu-
covered, my
Dattu
lord.
has said.
Only
They have
thing
to
is, my
comply
lord,
with the
I
order.
will just give you a very selective small figures, my lord. Admittedly, 61,636 number of booths.
61,000.
636.
Minimum 4 cameras.
I exclude, my lord, 1,000 booths, my lord, where there are uncontested things that has happened, my lord. 60,000. If your lordship goes by the round figure of
That is
60,000, my lord,
contested booths will be 61,636.
total 61. 636, my lord. If there are in 60,000 booths, if there are minimum of 4 cameras, my lord, minimum. 2 at the gate, my lord, and 2 inside, my lord, excluding the place where their actual polling is to be done, my lord. 240,000 number of cameras, my lord.
Is required.
That
Required.
requisition.
No,
Requisition has to be issued, my lord, and government has to advertise that. Somebody has to provide, my lord,
Can't
because
be calling
election
for
commission, my lord,
tenders.
election commission.
No, direction has been issued. Non-compliance is contempt. That's why you are here.
They have not
We'll
started
ask them for the figures. That's it.
during nomination,
Sir,
there was no videograph.
Wait. Either you address the court.
I'm sorry, my lord.
What is his concern? Your friend's
No,
concern.
my lord, I am instructing that regarding during the nomination, there was my lord direction that was not complied.
So your contempt is pending.
Yes.
Let them file an affidavit here also.
Fair enough, my lord. We'll come back on, since Mr. Dotto says that he will come back
We
with
have heard
instructions
also.
on Monday,
That
my
is-
lord. We'll come back on Monday.
No. We come back on Wednesday. only.
Grateful, my lord.
8:41. We have heard so and so. It is submitted by the learned advocate appearing for the applicant that the orders and directions issued by this court on 13/6 and 15/6/2023 have been affirmed by the Honorable Supreme Court. And that would mean that all directions issued should be scrupulously complied with. It is submitted that leaving aside the uncontested booths, there will be roughly about 61,636 booths in which elections will have to be held. And at least a minimum of 4 cameras are required to be installed. And it is submitted that it is not clear as to whether requisition has been made during the filing of nomination, the order and direction issued by the court for installing
Grateful.
was not complied with.
Grateful.
Was not complied with. We direct the State Election Commission to file an affidavit with regard to these issues. And while doing so, it should be borne in mind that all directions issued by this court in the 2 earlier orders have been affirmed by the Honorable Supreme Court. Let such affidavit be filed on or before 27/6/2023 and list this contempt application on 28/6/2023 at 2:30 p.m.
Deeply obliged, my lord. Well, I'm sorry for my juniors demeanor, my lord. Just exuberance of youth, my lord.
Oh, the thing is,
27
you can't hear.
yes.
So art of